Good afternoon, y'all. I'm your host, Supreme Litigant, and I'd like to welcome everybody back to Smart Low TV. Before we begin, if you don't mind, please go ahead and hit that subscription button, turn that notification bell on, and hit that like button. And I'll give y'all a few seconds to do that. All right, so I wasn't going to do another video, but I just decided to do one. So this video, let me make this a little bigger because I want y'all to really pay attention to this stuff. I've already talked about this on my YouTube channel before, but I'm gonna do it again. Well, let me change. I don't like the way that looks. Let me make that smaller. All right. So, this video I want to try to get y'all to understand or explain to y'all that what happens when constitutional courts, aka superior courts, exercise jurisdiction under statutes. They're exercising authority under statutes. So basically, this is it right here. Constitutional courts, i.e. superior courts, aka courts of general jurisdiction, acting under statutes are legislative courts, aka inferior courts, aka courts of limited jurisdiction. That is what they are. That's what they're doing. That is how they're confusing the shit out of everybody. So what do I mean by this? For example, this might confuse you a little. Hopefully it doesn't, but it may. I always say, since I've been studying this and I've been hearing other people say it, but now I have the cases to actually prove it. But I say, and I'm 100% sure of this, y'all, that there are two federal Supreme Courts. One of them is only a Supreme Court in name, meaning it's not really a Supreme Court. They're just calling it a Supreme Court. So what do I mean by that? All right, well, the Supreme Court, the federal Supreme Court, there are two ways to invoke its jurisdiction. You can use the Constitution, which is under the common law, or you can use a statute. If you're using a statute, that is another court. That is a legislative court. All right, y'all need to understand that. It's a legislative court. And since it's a legislative court, they don't have judicial authority. So I want y'all to understand this. If the legislature wanted to, let's say, wherever you are, let's say all over the country, if the legislature wanted to take the jurisdiction, let me rephrase that. If the legislature all over the country wanted to take their legislative jurisdiction, their statutory jurisdiction, from courts that were created by the Constitution and create an agency to adjudicate their public policy for them, they can do that. So when I say take their, let's say if the legislature all over the country wanted to take the statutory criminal and statutory civil jurisdiction from all courts that were created by the Constitution and create an administrative agency and let the agencies adjudicate them for them. The legislature can do that. They have the authority to do that. But they're not doing it because they're trying to trick you and fool you into thinking that you're in a court when you are not. You are in an administrative agency and you're not dealing with a judge. You're dealing with an executive administrator. That's what you're dealing with, who walks, talks, acts, and dresses like a judge. That is what is going on. That's what you're dealing with. And here's the case law to prove it. So this is an Alabama case law. But this is a principle. This applies everywhere. And I mean everywhere. I've seen cases all over the country stating this principle and recognizing this principle, even federal cases. But this is what it says. Accordingly, while the circuit court is ordinarily a court of general jurisdiction, in the particular proceeding now before us, it is made a court of limited jurisdiction by the statutes. It is the settled rule that where a special authority in derogation of the common law is conferred by statute on a court of general jurisdiction, It, meaning the court of general jurisdiction, becomes quad hoc an inferior or limited court. A compliance with the requisitions of the statute is necessary to its jurisdiction and must appear on the face of its proceedings. That's why there's a case law that says the law requires, I think it says the law requires the facts essential to the administrative hearing to appear on the face of the records in the affirmative. It's something like that. Something like that. Or the law requires proof of jurisdiction on the face of administrative proceedings. It's something like that. That's what they're talking about, y'all, when they say that, because it's an administrative proceeding and they don't have judicial authority. You're not dealing with a judge. You're in a territory. So let's go down. We're going to explain, because what I'm going to do is I'm going to explain to y'all what this means. So just bear with me. All right. Explanation of the passage. General jurisdiction versus limited jurisdiction. And I'm going to give you some examples. A circuit court is typically a court of general jurisdiction, meaning it has broad authority to hear a wide range of cases, which means it has civil jurisdiction, criminal jurisdiction, admiralty jurisdiction, common law jurisdiction, equity, marital. It doesn't need a statute to do any of that. And I don't know what they call the courts of general jurisdiction in your state, but whatever they call them, this principle applies there as well. However, in certain situations, statutes grant the court special authority to handle specific types of proceedings that deviate from common law principles, this should tell you that they're not operating under common law jurisdiction. And they're not. When this happens, the court's jurisdiction becomes limited to the scope defined by the statute. The term quad hoc, Latin for as to this, means that for the purposes of that specific proceeding, the court operates as a court of limited jurisdiction, not general. And since it's operating as a court of limited jurisdiction, it's legislative because the legislature writes the statutes. This also means that that so-called court has zero judicial authority because the legislature does not have any judicial authority to create a court and give it to anybody, because you have separation of powers. So if the legislature doesn't have judicial authority, what type of authority are they at? What is going on? What is going on? That's what they're doing. And I'm not 99% sure of that. I'm 100% sure of that. I have cases to prove it. Special statutory authority. When a statute confers a special authority that is in derogation of the common law, i.e., it creates a legal process or remedy not rooted in traditional common law. They're mimicking common law. They can copy it. They can mimic it too. But it's not common law, and they will do that. The court must strictly adhere to the statute's requirements. Everybody who's watching this video, if you've ever had so-called charges filed against you, go look at the complaint or the indictment or something, and they're going to be citing a code. That code is comprised of statutes which were written by the legislature. And I can guarantee you, I'm about 99% sure that that the court that prosecuted that case against you was a court of general jurisdiction. But it became a court of limited jurisdiction once they started exercising jurisdiction under the statute. The plaintiff always decides the jurisdiction, the plaintiff being the state. They pick the jurisdiction that the case will be prosecuted under. Anyway, examples of such special authority might include statutory procedures for tax foreclosures, eminent domain, or certain administrative appeals where the court's power is explicitly defined by statute rather than inherent judicial authority, like courts of general jurisdiction. They have inherent judicial authority. Jurisdictional requirements for the court to have jurisdiction, the legal authority to hear and decide the case, it must comply with the prerequisites, or in other words, with the requisitions of the statute. This means all procedural and substantive requirements outlined in the statute must be followed. Everything. These requirements must also appear on the face of these non-judicial executive administrative proceedings, meaning the court record must clearly show that the statutory conditions for jurisdiction were met, for example, proper notice, filing deadlines, or specific pleadings. And if you're in Ohio, you really need to watch this because I'm giving you an example from Ohio in the municipal court because Ohio municipal courts are courts of limited jurisdiction. They're pretty much everywhere, for real. Consequence of non-compliance. What happens when they don't comply? If the court fails to comply with the statutory requirements, it lacks jurisdiction over the case. Without jurisdiction, the court has no legal authority to act, and any orders or judgments it issues are void ab initio, invalid and unenforceable. This principle protects parties from being subjected to unauthorized judicial actions and ensures the statutory processes are followed precisely. Case law citations. The passage cites Alabama case, blah, 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 to support the rule that when a court of general jurisdiction exercises special statutory authority, it must strictly adhere to the statute's requirements or its actions are jurisdictionally defective. So I'm going to give y'all a couple examples out of Ohio. Using Ohio municipal court in a criminal case. Ohio municipal courts. Ohio municipal courts are courts of limited jurisdiction established by statute. I'm not sure if this is the right statute. They have jurisdiction over specific types of cases, including misdemeanor criminal cases, traffic violations, preliminary hearings and felony cases, certain civil, blah, blah, blah. Their jurisdiction is strictly defined by statute, and they lack the broad authority of Ohio's common pleas courts. So Ohio common pleas courts are courts of general jurisdiction. Once that court starts exercising jurisdiction under statute, it's a legislative court. Anyway, hypothetical scenario. Let's consider a criminal case in an Ohio municipal court where the state fails to properly invoke the court's jurisdiction. Case details. Charge. John Doe is charged with misdemeanor assault, a first-degree misdemeanor in Ohio, in a Toledo municipal court. Statutory requirements for jurisdiction. Under Ohio law, I don't know why they keep saying law. We're going to say under Ohio bylaw, a criminal case in a municipal court is initiated by the filing of a complaint that complies with Ohio Rule 3, Ohio Criminal Rule 3. The complaint must. These are the elements that a complaint needs to be valid. It's not all of them, by the way. But anyway, it must be in writing, state the name of the defendant, specify the offense charged, including the statutory section violated, be sworn and signed under oath by the complainant, i.e., a police officer or prosecutor before a judge, clerk, or other authorized official. The complaint must be filed with the court to invoke its jurisdiction. So what happens in this particular case? The state files a complaint against John Doe, but the complaint is defective because it's not sworn under oath. It's missing an element that it needs to constitute a complaint. So is it a complaint, and did it properly invoke the subject matter jurisdiction of that so-called court? No, the fuck it didn't. The officer forgot to sign it before a notary or judge. The court proceeds with the case unaware of the defect. We're going to say that the court knew about it. John Doe is arraigned, pleads not guilty, and the case goes to trial. He's convicted and sentenced 30 days in jail. What is his remedy? Who can tell me his remedy here? Because the jurisdiction hasn't been properly invoked. So everything, it's just smoke and mirrors, and they do this, y'all, by the way. Knowing damn well that their jurisdiction is not properly invoked, they will go all the way to trial, just ignore all your paperwork, ignore your arguments and all. They will do that. Happened to me before, a couple of times. His remedy, because this court, so-called court, issued a judgment, a manner that is inconsistent with due process. It violated due process. His remedy is a motion to vacate. That's one of them. That's what I would file. But anyway, jurisdictional defect. The failure to file a properly sworn complaint violates Ohio Criminal Rule 3 and deprives the Toledo Municipal Court of jurisdiction over the case. Ohio courts have consistently held that a valid complaint is a jurisdictional prerequisite in municipal courts. Now, I'm not sure if this is a correct case citation, but because I used software, so I'm not really sure. But this principle right here, this is 100% correct. Without a sworn complaint, the court lacks authority to proceed. Consequences: discovery of the defect. John Doe's attorney discovers the unsworn complaint during a review of the case and files a motion to dismiss for lack of jurisdiction. I think it would be too late to file a motion to dismiss. I wouldn't. It's too late to file that. I would file a motion to vacate. Well, you probably can file a motion. I don't know. Because I don't know. I would file a motion to vacate though. But anyway, alternatively, if the defect is discovered after conviction, the attorney files a motion to vacate the judgment or appeals to the court of blah, blah, blah. That's correct. Court's response: the municipal court reviews the complaint and confirms it was not sworn under oath. Because this is a jurisdictional defect, the court must dismiss the case if the motion is filed pre-conviction, or vacate the conviction if post-conviction, meaning if he's already been adjudicated guilty or if he's already been convicted, then they have to vacate it. The court's judgment is deemed void because it lacked jurisdiction from the outset, meaning from the beginning, because the state failed to properly invoke its jurisdiction. The burden is on he who asserts, not he who denies. If you file a complaint against a police officer in federal or state court, you have to properly invoke that so-called court's jurisdiction if and only if you are using statutes. You have to, the burden of properly invoking the jurisdiction is on you. Same thing for the state. It's on them. They're claiming they're plaintiff. They're using statutes. They have to properly invoke the jurisdiction. State's options. If the statute of limitations has not expired, typically 1 year from the misdemeanor, blah, 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 the state can refile the case with a properly sworn complaint. So when the type of dismissal that was referred to above would be a dismissal without prejudice, which means the state can bring the case back. That would be a dismissal without prejudice. A dismissal with prejudice would be that the state can't bring the case back against you. If the statute of limitations has expired, the state is barred from prosecuting John Doe for the assault, and the case is permanently, aka dismissed with prejudice, dismissed. Impact on the defendant. John Doe is released from all penalties, jail time, fines associated with the void conviction. The dismissal protects his due process rights, ensuring that the state cannot prosecute him without following proper statutory proceedings. They cannot enforce their rights while simultaneously violating your rights. They can't do that. Why this matters. Municipal courts, as courts of limited jurisdiction, rely entirely, let me rephrase that. Legislative courts, as courts of limited jurisdiction, rely entirely on statutory authority to act. Any deviation from the statutory requirements, like failing to file a sworn complaint, strips the court of the power to hear the case. This example illustrates the principle from the passage: even a court with broad authority, or in this case, a court with statutorily defined authority, becomes jurisdictionally limited when exercising special statutory powers, and strict compliance with the statute is essential. Now I'm going to give you a revised example. All right. Toledo Municipal Court, a court of limited jurisdiction under Ohio revised statute, with authority to hear misdemeanor criminal cases, traffic cases, blah, blah, blah. So this is a different charge. Well, no, it's probably the same charge. Anyway, the state attempts to charge John Doe with misdemeanor assault under Ohio revised code. Look at this statute. A first-degree misdemeanor. Okay. Issue. The state's complaint contains conclusory allegations or fails to charge an offense, but John Doe pleads guilty. He pleads guilty anyway, despite the fact that the state has not properly invoked their jurisdiction, and despite the fact that the state's complaint against him is full of conclusory allegations. What do I mean by conclusory allegations? We're going to explain it a little bit down here. The state files a complaint in the Toledo Municipal Court accusing John Doe of misdemeanor assault. However, the complaint is defective. In other words, it fails to charge an offense. It fails to properly invoke the subject matter jurisdiction of defense. Because why? It contains conclusory allegations, meaning it merely states that John Doe committed assault without specifying the essential facts of the offense. In other words, without providing John Doe with the facts of how they came to the conclusion that he committed assault. What did he do? Who did he do it to? How did he do it? See that? Example, who was assaulted, when, where, or how the act occurred. They have to give you that. If they don't, they violate due process. This is why pro se litigants lose in state and federal court on motion to dismiss against police officers when they sue them, because you can't say that this officer violated my rights, or he unlawfully arrested me, or he unlawfully detained me, without specifying the essential facts of the cause of action. You have to give him the facts. So once this case is dismissed against him, you can't refile it against him. You have to give him due process. If you can't do it in a criminal case, what makes you think you can do it in a civil case? Because you can't do it. Fails to charge an offense, such as omitting the statutory elements of assault, knowingly causing or attempting to cause physical harm to another, or failing to cite the correct statute, something like that. These are correct too, by the way. For example, the complaint might read on or about, let's say this is the state's complaint, and this is the only allegation, this is the only so-called factual allegations that they made against you. On or about June 1st, 2024, John Doe committed assault in Toledo, Ohio, in violation of Ohio law. That is vague and conclusory as hell. I don't know what the hell you're talking about. I don't know what I did. I don't know who I did it to. I don't know how I did it. What the hell are you talking about? This is conclusory because it lacks specific facts about the incident and does not articulate the elements of the offense. Y'all gonna learn something on my channel. Y'all hit that like button. You're gonna learn something on my channel. I know what the hell I'm doing, and if I don't know what I'm doing, I'm gonna figure it out. And if I'm ever wrong about something, I'm gonna come back, hey, y'all, I was wrong. I apologize about that. This is how I was wrong. Let me fix that. Boom. That's how I'm gonna do it. Because I'm still learning too. I'm not a guru. I'm still learning this stuff. But my paperwork drafting skills are just top tier. But I still make mistakes every now and then. And yours will be top tier too. You just have to keep reading and keep drafting your paperwork. Shout out to I ain't gonna call your name. Frog, you getting it, man. You getting it. Statutory and procedural requirements. Under Ohio Criminal Rule 3, a complaint must be in writing and made under oath. Okay. State the name of the defendant. Specify the offense charged, including the statutory section violated. Contain a statement of the essential facts constituting the offense. Ohio case law emphasizes that a complaint must include sufficient factual details to inform the defendant of the nature of the charge and establish, the nature of the charge and establish the court's jurisdiction. Go down a little bit more. The Toledo Municipal Court's jurisdiction over criminal cases is limited to offenses properly charged within its statutory authority. What happened? Despite the defective complaint, John Doe, he's arraigned again. This is just another scenario. He got arraigned again. The court reads the vague charge. And John Doe, unaware of the complaint's deficiencies and perhaps without counsel, pleads guilty to the misdemeanor. He shouldn't even been arraigned because the state failed to properly invoke the jurisdiction. It's just smoke and mirrors, y'all. The court accepts the guilty plea and sentences John Doe to 30 days in jail and fines him $50. Later, John Doe consults an attorney who discovers the complaint's defects, conclusory allegations, and failure to charge an offense. This is vague, it's conclusory, and is legally insufficient as a matter of law. Jurisdictional defect. The complaint's conclusory allegations and failure to charge an offense violates Ohio Criminal Rule 3 and deprives the Toledo Municipal Court of subject matter jurisdiction. Subject matter jurisdiction refers to the court's authority to hear a particular type of case, misdemeanor assault, for a municipal court to have jurisdiction. The complaint must properly allege an offense within the court's statutory authority. Ohio courts have held that a complaint that fails to state the essential elements of an offense or provide sufficient factual allegations does not invoke the court's jurisdiction. It's just smoke and mirrors. They're just playing. You don't know, but you don't know what you don't know. The Ohio Supreme Court ruled that a defective charging document renders a conviction void for lack of jurisdiction, even if the defendant pleads guilty, because their jurisdiction is extremely limited, because they are so-called courts of limited jurisdiction. The principle from the original passage applies here. The Toledo Municipal Court as a court of limited jurisdiction. Let me rephrase that. The legislative courts as courts of limited jurisdiction becomes I'm gonna read it again. Let's just say I'm gonna keep it. I'm just gonna read it. I'm gonna read what it says. The Toledo Municipal Court as a court of limited jurisdiction becomes quad hoc for this purpose, a court of strictly limited authority when exercising its statutory power to hear criminal cases. The court's jurisdiction depends on compliance with the requisitions of the statute, Ohio Rule 3 and Ohio Revised Code. Excuse me. The defective complaint fails to meet these requirements, meaning the court's jurisdiction was never properly invoked, and it's just smoke and mirrors. Non-jurisdictional defect. So in order for you to vacate the judgment, it has to be a jurisdictional defect, not a non-jurisdictional defect. A guilty plea generally waives defects in the complaint that are non-jurisdictional, such as minor errors in form or technical inaccuracies, as long as the defendant was adequately informed of the charge. Jurisdictional defects. However, a guilty plea does not waive defects that deprive the court of subject matter jurisdiction. Ohio courts have consistently held that jurisdictional defects render a judgment void, and I'm pretty sure this applies everywhere because this is a principle. And such defects can be raised at any time, even after a guilty plea. In this case, the complaint's failure to charge an offense or provide essential facts is a jurisdictional defect because it does not establish that an offense within the court's authority was committed. It's also a violation of due process. As a result, John Doe's guilty plea does not cure the defect, and the court's judgment remains void. Consequences. Discovery of the defect. John Doe's attorney files a motion to vacate the judgment under Ohio Criminal Rule 47 or petition for post-conviction relief under Ohio Revised Code, blah, blah, blah. Notice they keep saying these codes, y'all. Arguing that the court lacks subject matter jurisdiction due to the defect of the complaint. Alternatively, if John Doe is still within the appeal window, 30 days from sentencing, under the Ohio Appellate Rule 4, he can appeal the conviction to the Ohio Court of Appeals, raising jurisdictional issues. Yes, that is correct. Court's response. The Toledo Municipal Court reviews the complaint and finds that it contains only conclusory allegations and fails to allege the essential elements of the assault. Because this defect is jurisdictional, the court must vacate the conviction and dismiss the case. The judgment is deemed void ab initio, invalid from the outset, and not when they realize that they didn't have jurisdiction. It's void from the outset, meaning it has no legal effect. John Doe is released from all penalties, jail time, fines, and the conviction is erased from his record. State's option, if the statute of limitations, obviously like it was before, they can just refile it if they're still within the statute of limitations. Let me see. It says why this matters. I think I'll read a little bit more of this. Well, you know what? I'm not, because I think y'all get the picture now. I think you get it. So again, when constitutional courts, aka courts of general jurisdiction, aka superior courts, starts exercising jurisdiction under statutes, they are legislative courts, aka inferior courts, aka courts of extremely limited jurisdiction, and they don't have any judicial authority. You are in a territory. They are tricking you. They are lying to you. That's what they're doing. If you're in your if you are in, I don't care whatever state you're in. If any state court is exercising jurisdiction under a statute, they are not so-called judges, and they don't have any judicial authority. It's essentially like it's like there's two circuit courts, there's two district courts, like there's two of the same courts everywhere, except one of them is actually an inferior court because they're exercising jurisdiction under statutes. That's what they're doing. That's what's going on, and they're doing it everywhere, everywhere. So hopefully, y'all start reading your state constitution and reading cases to help this stuff get embedded into your minds. But anyway, that'll be it. The Supreme Litigant is out. Peace.